This is Constitutional Rights in Black and White.
Dee Farmer was a trans woman. In 1986, she was sentenced to 20 years in federal prison for identity theft. She was transferred to Leavenworth, a men's maximum security prison. Even then, the risks to trans women in men's prisons were well known, and according to policy, she should have been placed in protective custody or other safe housing. Instead, she was put in general population, where she was physically and sexually assaulted. Dee Farmer sued, and her case went to the Supreme Court, where she argued that correctional officials showed deliberate indifference to her safety and therefore violated her rights. Maybe they did, maybe they didn't, said the Supreme Court. They only violated your rights if they were actually aware of the risk to you. But wait, said Farmer, the Eighth Amendment prohibits the infliction of cruel and unusual punishments. Everyone knows that trans women like me are at high risk for physical and sexual assault if we are housed with male prisoners. Because of the prison's decision, I suffered unspeakable physical and psychological harm. The Eighth Amendment protects me from this kind of institutional failure, no matter what any individual official might have thought. No, the Supreme Court said it doesn't. The Eighth Amendment does not outlaw cruel and unusual conditions. It outlaws cruel and unusual punishments. And the harm to you only counts as punishment if some prison official was aware of it. If they didn't know about the risk of harm to you, it doesn't count. But it's their job to protect my health and safety, said Farmer, and they ignored it. The state has chosen to incarcerate me, so I have no way to protect myself. I have to rely on corrections officials to keep me safe. True, said the Supreme Court, prison officials have a duty to protect people from violence at the hands of other prisoners. But the Eighth Amendment only protects you from harms that officials are aware of. An official's failure to alleviate a significant risk that he should have perceived but did not, while no cause for commendation, cannot under our cases be condemned as the infliction of punishment. This seems like a terrible definition, said Farmer. So you are saying that if a prison official is too careless or ignorant or incompetent to realize the risk to people's health and safety, they will not be held legally responsible for the harm that actually occurs, even if any reasonable person paying attention would have realized the risk? Basically, yes, the Supreme Court said. Farmer turned out to be one of the most important prisoners' rights cases. By defining deliberate indifference as actual awareness of the risk, it shields prison officials from an enormous amount of liability and exposes people in prison to an enormous amount of harm. Okay, let's read the case. The Eighth Amendment famously prohibits the infliction of cruel and unusual punishment, and the Supreme Court has held that the Eighth Amendment thus requires that prison officials keep people safe while they are incarcerated. For decades, the court interpreted this mandate to mean that prison officials cannot engage in deliberate indifference to prisoner health and safety. Farmer versus Brennan is about what that means in practice. Put differently, Farmer is about how we operationalize the obligation imposed by the Constitution and indeed by our basic moral commitments to keep people safe when we lock them up. Farmer decided what might seem like a somewhat technical legal question. What is the legal standard for Eighth Amendment deliberate indifference claims? But the way the court answered the question made Farmer one of the most important constitutional decisions in prison law. It protects prison officials against liability even for egregious safety violations, and thus exposes people in prison to egregious risks at the hands of the people in charge. In this particular case, as we saw, Dee Farmer was a trans woman. Prison officials put her into general population in a men's maximum security prison, despite the well-known and obvious risks to her safety. She was sexually assaulted and she sued, arguing that the prison officials showed deliberate indifference to her safety and thereby violated her Eighth Amendment rights. The big decision that the Farmer Court needed to make was to pick a standard by which to evaluate deliberate indifference on the part of prison officials, to decide what state of mind prison officials must have had to be found to have violated their constitutional duty of care. There were two basic options, a subjective one and an objective one. Lower courts were split on which one was right. One was the standard of criminal recklessness. Under that standard, a defendant is liable if they were subjectively aware of the risk. The other was the standard of gross negligence, also known as civil recklessness. Under that standard, a prison is liable if a reasonable corrections official would have realized a substantial risk of serious harm, even if this particular defendant did not. There are several key moments in the decision as the court crafts the new standard. First, Justice Souter recognizes that the state has an affirmative obligation to keep people safe, that prison officials have a duty to protect prisoners from violence at the hands of other prisoners. We can think of this as the state's carceral burden, the burden the government assumes when it locks people up, thereby leaving them unable to care for themselves or to ensure their own safety. Justice Souter writes that having incarcerated persons with demonstrated proclivities for antisocial, criminal, and often violent conduct, having stripped them of virtually every means of self-protection and foreclosed their access to outside aid, the government and its officials are not free to let the state of nature take its course. The court then has to decide by what standard that duty, that carceral burden, will be evaluated. The court had already held in the prior cases of Wilson versus Sider and Estelle versus Gamble that in order to violate the Eighth Amendment, a prison official must have a sufficiently culpable state of mind, a state of mind that is one of deliberate indifference to inmate health or safety. The court had also already decided that deliberate indifference, on the one hand, describes a state of mind more blameworthy than negligence, and at the same time, it is something less than purpose or knowledge. The classic intermediate standard that reflects this balance is called recklessness, but as the court notes, the term recklessness is not self-defining. The court defines recklessness for Eighth Amendment purposes as a subjective standard. In order to be found liable, a prison official must know of and disregard an excessive risk to inmate health or safety. The official must both be aware of the facts from which the inference could be drawn, and he must also draw the inference. Notice what a consequential decision this is. With this one seemingly small move, the court basically excuses failures of care in all those instances where any reasonable person, anybody paying attention, would have been aware of a risk. Even prison officials who do not perceive a risk because they are careless, incompetent, or even doing something entirely unrelated to their job, reading a magazine, surfing the internet, will be given a free pass for their failures to investigate, failure to monitor, or failure to take action. Recall that these are the very officials who are primarily and often solely responsible for ensuring the safety and health of people in prison. In coming to this decision, the court relies on a narrow and formalistic definition of punishment itself. Recall that the Eighth Amendment prohibits cruel and unusual punishment. When a person is sentenced to prison, the punishment is being deprived of their freedom for the specified time. One might think that someone who is subjected to violence, disease, or other harmful conditions during their incarceration is receiving additional punishment. But the court does not see it that way. Instead, the court writes that the Eighth Amendment does not outlaw cruel and unusual conditions. It outlaws cruel and unusual punishment. The court holds that an official's failure to alleviate a significant risk that he should have perceived but did not, while no cause for commendation, cannot under our cases be condemned as the infliction of punishment. In other words, if officials did not realize the risk, the resulting harm does not count as punishment. This holding was invited by the court's 1991 case, Wilson versus Sider, where it held that prison conditions don't count as punishment under the Eighth Amendment unless some culpable officer caused the harm. If the pain inflicted is not formally meted out as punishment by the statute or sentencing judge, some mental element must be attributed to the inflicting officer before it can qualify. Not all the justices agree that this is the right approach. Justice Blackmun, for example, pushes back against this formalistic definition of punishment, complaining in his concurrence that the court's analysis is fundamentally misguided, indeed it defies common sense. He argues that an official's state of mind might have nothing at all to do with whether a prisoner experiences punishment, and that the court's unduly narrow definition of punishment blinds it to the reality of prison life. Consider, for example, a situation in which one individual is sentenced to a period of confinement at a relatively safe, well-managed prison complete with tennis courts and cable television, while another is sentenced to a prison characterized by rampant violence and terror. Under such circumstances, it is natural to say that the latter individual was subjected to a more extreme punishment. But Justice Blackmun's view did not carry the day. The Farmer decision has profound implications for prison litigation. I'll flag just a few of them here. First, it has implications for how hard it is for litigants to prove deliberate indifference. On the one hand, the court points out that a prison official's state of mind can be inferred from the nature of the risk, or as the court puts it, in the usual ways, including inference from circumstantial evidence. For example, a fact finder may conclude that a prison official knew of a substantial risk from the very fact that the risk was obvious. This suggests that even when an official claims ignorance of the risk, a jury might disbelieve them because the risk was so obvious and clear as it was for D. Farmer herself. On the other hand, the court weakens the force of these inferences when it explains that the inference cannot be conclusive, for we know that people are not always conscious of what reasonable people would be conscious of. Notice how this is an invitation to judges and juries to accept the word of an admittedly unreasonable prison official, even when they've permitted great harm to befall a prisoner, even when anyone paying the least attention would have realized the danger. Practically speaking, the arguments that Farmer requires are difficult to make. It's hard to prove that a particular person had a particular state of mind. Most prison litigation is brought pro se by prisoners themselves, who have no right to counsel and no training in legal rules, drafting, or depositions. You can see how it might be very difficult for people in prison to thread the needle through the very narrow space left by Farmer. Institutionally speaking, Farmer creates destructive incentives for prison officials. It invites ignorance and inattention to people in prison and the risks they face. The court emphasizes that constructive knowledge is not enough. The defendant must have subjective culpability. Accordingly, as long as the official can claim that they were unaware of the risk, they will avoid liability. This is, to say the least, a counterproductive message to send to the very people, indeed often the only people, responsible for the health and safety of people in prison. Finally, and more recently, Farmer had powerful implications during the pandemic on the way that officials handled COVID in carceral institutions. Farmer held that prison officials who are subjectively aware of the risk can still avoid liability if they responded reasonably to the risk, even if the harm ultimately was not averted. During the pandemic, the whole world was aware of the enormous risk to prisoners who were trapped in highly infectious, overcrowded environments. And in fact, thousands were infected, and during the first year of the pandemic, incarcerated people died at 3 times the rate of people in society as a whole. Many U.S. prison officials who were highly aware of the risk nevertheless took partial and inadequate measures to protect prisoners, failing to provide opportunities for distancing, providing few masks and little or no soap, and failing to quarantine sick people. And yet, courts around the country routinely excused those officials from liability, treating partial measures as reasonable responses, even though prisoners were getting sick and dying in grossly disproportionate numbers, and even though prison officials must have known full well that the steps they took were not nearly enough to protect vulnerable people inside from COVID. Those deaths are also part of Farmer's legacy. On its face, Farmer might look like a modest doctrinal move. It's just picking a legal standard. But in fact, it may be the most impactful case in prisoners' rights because it sets such a high bar to show a violation of the Eighth Amendment. It creates a vast zone of official discretion and impunity when it comes to the people in prison who have no way to protect themselves from violence and disease, and who therefore must rely on state officials to keep them safe. Farmer also creates strong affirmative incentives for prison officials to ignore prisoner safety, or, as the court puts it, to act in ways that are not commendable. In effect, it lightens the state's carceral burden to protect the people it incarcerates. The decision is also an evasion of the reality on the ground, because the standard focuses solely on the individual mindset of individual officials and not on the prison bureaucracy. Bureaucratic knowledge, it's fragmented, it's collective. No single official may have full knowledge about the harm to a particular prisoner. Or, as Justice White wrote in dissent in Wilson, inhumane prison conditions often are the result of cumulative actions and inactions by numerous officials inside and outside a prison, sometimes over a long period of time. An individualized standard is therefore a recipe for underprotection. Put differently, imagine if Farmer had come out the other way, if the court had picked the objective test and required that prison officials act reasonably. Then the prevalence of violence, of rape, disease, and inhumane conditions in American prisons would clearly violate the Eighth Amendment because they are clearly and objectively unreasonable. Simply by picking a different legal standard, the court could have required that those who run the prisons take seriously their constitutional duty of care and transform the way we treat the people we have opted to punish with prison.
Big thanks to Professor Sharon Dolovich for contributing her analysis to CRBW. Professor Dolovich is a leading scholar of prisons, punishment, and the Eighth Amendment. She is director of the UCLA Prison Law and Policy Program and the founder of the UCLA Law Behind Bars Data Project. We're very grateful that she took the time to share her work with us.